You're listening to a Times Higher Education podcast.
Hello there, welcome to News Talks, the Times Higher Education podcast in which we discuss the biggest stories in global higher ed. I'm your host, Miranda Prynne, and I'm joined today by our Editor-in-Chief, Chris Havergal. Chris, great to have you back in the News Talk studio.
Thanks for having me back, Miranda. Nice to see you.
Now, last time we spoke on News Talks back in February, it was to discuss the legal challenge mounted by the University of Sussex against the Office for Students over a record £585,000 fine imposed upon Sussex by the Office for Students for failing to uphold freedom of speech. Yesterday, we learnt that the University of Sussex had been victorious in its challenge, and the much anticipated High Court ruling had found in favour of the institution, essentially overturning the OfS fine, claiming the regulator had acted beyond its powers. This is big news for UK higher education, with potential ripple effects that will extend far beyond the removal of this hefty fine for Sussex. But Chris, first, can you provide a quick revision session on this case and explain what lay behind the OfS fine, as this is pretty fundamental to understanding the likely impact of the judgment?
Yeah, this is actually a case which stretches all the way back to 2021 when Kathleen Stock, who is a gender-critical philosopher, resigned from Sussex, and that followed protests by students about her views on gender. The OfS, the regulator for the English higher education sector, started an investigation, but funnily enough, the investigation actually has little to do with the exact circumstances of Stock's departure or whether her academic freedom actually had been infringed, but on Sussex's policies and whether these had the potential to infringe on academic freedom, in particular, policies relating to trans and non-binary equality, and the need for, in particular, course materials were described as having to positively represent trans people and trans lives. That investigation stretched on for more than 3 years, with, as you say, the OfS eventually concluding that Sussex policies could have, well, they found a chilling effect on academic freedom and might lead to students and staff self-censoring to avoid disciplinary action for expressing what were lawful views. So, as you say, a fine of extraordinary sum, 585,000, was imposed. Sussex challenged that case. It went to trial in February. And as you say, that ruling has now been handed down.
Yes, and one of the things the university argued was that these policy documents didn't constitute a governing document and thus sat beyond the OfS remit for its investigation. And there were a number of other key points upon which the university challenged the fine, which we discussed in detail in our previous podcast on this topic. But on what basis did Mrs Justice Lieven find in Sussex's favour?
Yeah, I mean, this was a pretty comprehensive victory for Sussex. There were many points which Sussex challenged the OfS on, and it's not as if it was a sort of finely balanced one where it was, 6 of one, half a dozen of the other. Sussex comprehensively won this case. You're right to flag the issue about governing documents. This wasn't one of the sort of main statutes of the university. It was considered, therefore, that the OfS definition of these policies being governing documents was too broad, and the judge took the view that the regulator cannot be expected or required or even desired to rule on every policy at every institution in English higher education. So this was a case of overreach, essentially. She took the view that I think the OfS had overlooked the notion that free speech, while absolutely paramount to protect on campuses, cannot be absolute. There may be compelling reasons why an institution may take steps to restrict that and balance it with its other policies. And the judge considered that the OfS just hadn't really given due importance to that. She took the view that the OfS decision overlooked Sussex's case that while it had these policies on trans rights and things, the OfS has sort of overlooked the idea that Sussex would actually say that actually the right to academic freedom would be balanced and in many cases would sort of overpower some of those policies, and felt that the judge felt that the OfS had wrongly taken the view that staff could lose their job as a result of breaching these policies. Sussex said, look, actually that would never be the case. One other important point is that actually by the time that Sussex was the subject of this OfS decision, it remedied this. It's not actually in dispute that some of these policies were not good, may have restricted academic freedom and should have been reformed. Sussex took that on board, and by the time it took the decision, it had revised these, in fact, revised them several times. And the judge said that the OfS should have taken that into account rather than ploughing on with the fine. There's one final thing, and I think actually the most damning finding that the judge made. So basically, the OfS had predetermined this case. It had made up its mind before it started its investigation, or at least got into its investigation. The judge found that the regulator, in particular Susan Lapworth, who was chief executive of the OfS for much of this time, had wanted to respond to concern about free speech on campus, particularly political concern about free speech on campus, I think, by making an example of a university and setting a precedent in the sector. And it just so happened that Sussex was the university that they chose to do that because of the Kathleen Stock case. In fact, many other universities had very similar policies in place at this time. But the judge's reasoning is that if you'd have chosen to make an example of a university, it follows that the only way they could have achieved that is by finding a breach and issuing a sanction and having all the publicity that came with that. And there's a lot, this played out in the OfS refusing to settle the case with Sussex unless Sussex accepted the breach in full, refused to take account of the fact that Sussex had sorted this by the time it came to issuing the fine. And just hadn't balanced the arguments correctly. So, yeah, as I say, a very damning judgment and an overwhelming win for Sussex.
Yes, although these judgments are rarely entirely straightforward. Were there any points upon which the Office for Students was vindicated?
Yeah, in a couple of areas, but fairly sort of technical areas. Sussex threw the kitchen sink at the OfS, as you do in cases like this, and you wouldn't expect to win absolutely everything. I suppose one of the key arguments was Sussex had actually argued that the only person who could rule on their governing documents would be the King, because he is technically the visitor of Sussex, as he is a number of other universities. That always seemed like a bit of a stretch, and the judge said that, look, clearly it can't be the case that you have a higher education regulator, but actually the person who could rule on these things is the monarch. That's pushing it too far. There were some other small wins for the OfS in terms of whether it had disclosed enough evidence to Sussex. And indeed, there was an argument about whether this case would indeed have a chilling effect. The OfS hadn't really sort of proved this, and there was a case then that, if you can't prove there's been a chilling effect, how can you say there has been? The judge was like, well, actually, the very nature of a chilling effect may mean that people would be unwilling to come forward and talk about it, or at least reluctant. So, you don't have to prove that harm occurred. The risk of it being, that it might happen, it is sufficient. But as I say, these are fairly sort of minor victories in the overall scheme of things, and that massive fine has now been overturned.
So clearly the University of Sussex will be celebrating this result. Their Vice-Chancellor and President, Sacha Roseneal, has already put out a statement to that effect, which said she was, I quote, "delighted that Sussex's foundational commitments to academic freedom and freedom of speech have been recognised by the High Court, and that the OfS's egregious decision against the university and the fine it sought to impose have been overturned." So that's the position from Sussex, of course. But how will the rest of the UK sector feel about this ruling?
Yeah, this is a bit of a funny one, because I've spoke to many vice-chancellors during the time of the investigation, in particular the court case. And a lot of vice-chancellors would actually question whether Sussex were right to take this case to court, in part reflecting how the debate on trans rights has moved on in recent years, and perhaps a fear that universities would be seen on the wrong side of a debate when there is now significant recognition and protection of gender critical beliefs. And also perhaps concern about just how much bandwidth this must have taken up for Sussex in over the last 4 years. You've got a university there that's effectively been in crisis mode for 5 years, from COVID, Kathleen Stock, straight off the back of that, let alone the financial challenges that it faces and the drop in international students, which it, like many institutions, is facing. So I think a lot of people would question whether this was the right thing to do. So on that basis, credit to Sacha Roseneal for bringing the case. That decision has now been vindicated, and that probably reflects just how strongly Sussex felt that it had been wronged by the OfS in this case. And so those questioning voices clearly are now quieter. Whatever we say about the specifics of this case, though, many leaders in the English sector are deeply troubled by the role of the OFS, which they view as being overly combative, too burdensome, and overreaching as a regulator. And many will be glad to see it taken down a peg and would hope that this would lead to a broader change of approach and tone from the OFS, or indeed government reform of how we regulate English higher education. At the same time, though, there are many advocates for freedom of speech in the English sector who see academic freedom being constrained by overzealous managers, by equality, diversity, and inclusion advocates, and they're very concerned by this ruling. They don't trust institutions to resolve this issue themselves of freedom of speech. They want regulatory control to ensure that academic freedom is protected. And they see the loss of jurisdiction over the sort of policy, university policies, that's tight restriction to governing documents only, as sort of taking out a key tool in a regulator's armoury to address this issue. Many of them are fearful that the Higher Education Freedom of Speech Act, which was passed since this case first arose, but sought to address many of the issues, is possibly left a bit toothless by this judgment. Now, that remains to be seen, but it does show just how sort of complex this case is and how it perhaps sort of touches on many of the pressure points in English HE at the moment, whether that's free speech, how you feel about the regulator, gender critical beliefs, for example, that many in the sector will still have very diverging views about the judgment and about the case, even though it was a pretty sort of comprehensive win for Sussex on legal grounds.
Yes. What do we know about the Office for Students reaction so far? Has anything been heard, for example, from its freedom of speech czar, Arif Ahmed, the former Cambridge University philosopher who led the investigation into Sussex, and whether his role is still considered tenable?
Let's first actually start with Susan Lapworth, who was the staff member at the OFS who really came in for strong criticism for the judge, who was seen to have sort of driven this case forward and, really to have driven that predetermination, which was a key part of the judge's ruling. She's no longer at the OFS, as we said. She stepped down a few months ago. If she was still there, I think her position certainly would be pretty untenable. So we've heard from Josh Fleming, who's the OFS's interim chief executive, who says the OFS is disappointed and will consider the ruling before deciding on next steps. He says, to quote, that the OFS will reflect on the judge's findings and use them to help inform our future approach. The OFS claims it can take some comfort from the fact that Sussex and other universities that did have these policies did change them as a result of the investigation, and that those policies, are now acknowledged to have had the potential to restrict freedom of speech. But yes, you mentioned Arif Ahmed, and it's perhaps interesting we haven't heard from him so far because he is the OFS's freedom of speech director. The OFS ran a briefing for journalists in the aftermath of the ruling, and you might expect that he would be on there, but he wasn't. His position on this case is quite interesting because he certainly had the potential to be seen as being sort of conflicted and predetermined in this case. Before being appointed, he had expressed support for Stock and criticised Sussex behaviour. So when he joined the regulator, he was considered to have a conflict of interest and wasn't put on this case. And the judge says it's surprising that a year later, he then was ultimately put in charge of the investigation. Now, the case of Susan Lapworth, who was the person who put Arif Ahmed on the case, was that by this point, the decision had largely been settled, and Arif Ahmed didn't have a pivotal role in deciding how the case would ultimately end. The judge largely accepts that and finds that there's no evidence of any bias on the part of Arif Ahmed being key to the outcome of this case. But there's no doubt that Arif Ahmed was closely involved in the sort of conclusion of this case and has played a key role in setting out the OFS's free speech agenda since then, which has to a significant extent been shaped by the ruling which it made in the Sussex case. We've spoken to Sasha Roseneal, the Sussex Vice-Chancellor, who said that in her opinion, Arif Ahmed's position is pretty untenable. I don't know. I think with the comments that the judges have made, there's room for him to say, look, I wasn't biased and to survive. But I suppose it's more really about his agenda and the role of free speech at the OfS. He's been in post for several years now, and while there have been lots of policies and consultations, there's not a great deal tangible to show for it in terms of regulatory activity. The Sussex case was the OfS's signature intervention on free speech, as it were, and it's blown up spectacularly in the regulator's face, and that undoubtedly does leave Arif Ahmed in a difficult position.
As you say, during the OfS investigation, we saw a lot of universities quietly removing similarly worded policies relating to the representation of trans people. And of course, it had wider implications for other equity, diversity, and inclusion related policies designed to protect the many different groups that form the university community against negative treatment. So, could this be seen as a win for EDI in the UK?
It's tempting to see it that way, and I know some people have. I'd be wary of pushing that too far. I think Sussex did acknowledge that some of the policies, as we said, did have the potential to breach free speech requirements and has amended them, and has acknowledged that in cases like this, free speech remains paramount. Other universities have followed suit. I don't actually see much sign that they're going to change them back in a hurry in the wake of this ruling. Got to see all of this in the context of the shift in debate over trans rights and protection given to gender critical perspectives. The key ruling there has actually been the Supreme Court case against the Scottish government, and we're still waiting for final guidance on what that means for things like single-sex spaces and the expression of gender-critical beliefs on campuses and elsewhere. But clearly the dial has shifted on this debate. So I don't actually see those policies just being rolled back. Where it might prove more influential, perhaps in slightly more nuanced ways, there's this implicit acceptance in the judge's ruling that free speech isn't always absolute, and that even where speech is lawful, universities have a legitimate interest in creating an inclusive community and also an effective learning environment. There was a Sussex policy which said curricula shouldn't advance stereotypes of trans people, and actually the judge found that would actually be in some ways a reasonable judgment thing for a university to be involved in. Curricula are absolutely key to the functioning of universities, and actually if you're relying on stereotypes to teach, that wouldn't be a very effective teaching method. So you might see just a bit more willingness on the part of universities to perhaps balance that need to protect freedom of expression with the need to protect others from harm, real or perceived, and that could extend clearly to minority groups.
Yes, because just because something's lawful to say doesn't necessarily mean that within a kind of community environment you want people to say it if it's going to do harm to others in that community. So yes, it is a nuanced thing. Sacha Rosenhill, as you've already pointed out, did not hold back from laying into the Office for Students off the back of this ruling. She called it a devastating indictment of the impartiality and competence of the OfS, and called into question its operations, leadership, governance, and strategy. She has also said that she wishes to meet with the Education Secretary to discuss these issues and find better ways to regulate and support universities. So I wonder if you have any inkling what shape might this better approach to regulation of the sector look like in her eyes?
I think certainly on free speech, Sacha Rosenhill and indeed other vice-chancellors would want a regulator that continues to champion it, but understands the complexities of supporting free speech in a campus environment rather than taking an absolutist approach, and one that supports universities to protect free speech rather than haranguing them and indeed taking them regulatory action about it unless that's really needed. I suppose to take another example and another sort of hot potato topic on campus, Gaza and the Israel-Palestine conflict, we had encampments on many university campuses, and during that period there was a huge amount of haranguing of vice-chancellors over sort of allegations of anti-Semitism and things like that, which clearly would be issues of concern. But beyond the haranguing, there wasn't actually very much firm guidance from the regulator on how, in that situation, when you want to limit the risk of anti-Semitism, how do you at the same time protect the right to protest of many people who were concerned about the conflict in Gaza, and very little specific guidance about are there particular posters or phrases that protesters might use that might cross the line in a case like this. So this is the same on the gender debate. The judge found that if the OFS really wanted to be an effective regulator and solve the problem it was seeking to solve, rather than fining Sussex and conducting a very long investigation before even getting there, it could have told Sussex and the dozen or so other universities that had such policies to revise them. And that comes down to this idea, and Sasha's sort of quote is she'd like a regulator that works with the sector, not against it. There's just a general sense that the OFS has been too combative, too burdensome in its approach. And you've got to remember that it's dealing with a sector that is in crisis, in financial crisis, which is shedding thousands of jobs every year. There's a general sense that the OFS has perhaps been unduly fixated on freedom of speech and a range of other ministerial pet passions, as it were, when what the sector really needs is support to navigate a financial crisis, achieve collaboration between institutions in order to survive. And it feels like we've heard less from the OFS about that.
Yeah, so a more collaborative approach to regulation to help everyone improve and work together. All this, of course, also comes at a time when the government is planning to hand even more power to the OFS as the regulator, such as an impending free speech complaint scheme, for example. How might these plans be affected by this ruling?
Yeah, that complaint scheme is now due to come in this summer, and the OFS insists that it will go ahead. It's worth reiterating that the Sussex case preceded the introduction of the Freedom of Speech Act, which arguably will give the OFS more power to investigate this case, and certainly to investigate it in a more sort of straightforward way, focused on freedom of speech, rather than trying to shoehorn questions about freedom of speech into an existing regulatory framework, which was much more focused on governance. But as Smita Jamdar, who's a leading HE sector lawyer, has written for us following the Sussex judgment, that the problem is that much of the approach that underpins that complaint scheme, and as we've said, the OFS approach to free speech more broadly, has now been found to be flawed. Whether that's about predetermination, whether that's about where they draw the line in terms of his speech being impeded or not. And if it is about where you draw the line, arguably the OFS could proceed with the policies that it's got, but just draw the line better in future. It could try to do that. There's another problem here, though, that the OFS did sort of single Sussex out, and its general regulatory approach has been to sort of sample universities rather than looking at an issue at a whole. It said, right, we're going to look at highly selective universities, or we're going to look at business and computing courses or something like that, and we're going to look at a handful of those and then take regulatory action where we find it. And the problem is, in the case of Sussex, it was found, well, actually, if you're singling institutions out like that rather than taking a view across the sector of where the issues are, you're possibly opening yourself up to accusations of predetermination and not just simply not being fair as a regulator. So it remains to be seen, I suppose, sort of what will change and whether it actually means change in terms of policies. But undoubtedly, the OFS does need to demonstrate that the way it applies its policies, the way it approaches free speech as an issue, has changed. It will need to do that to maintain the confidence of policymakers, but I think perhaps also most importantly, to maintain the confidence of universities, because the relationship between universities and the OFS was already very difficult, and I think it's even more challenged now.
Yeah, so I mean, in conclusion, might this mark a turning point for the role of the OFS, which was, after all, set up in a very different era for higher education? Is it perhaps time for the regulator to take on a more supportive than critical role, given the huge challenges faced by UK higher education?
Certainly many in the sector would like to see that. The OFS has been around for 8 years now, and it's had that sort of very adversarial, confrontational approach often to the way it deals with universities. I think it has recognised, and it's been told repeatedly by multiple sort of reviews, that approach isn't really working. It's not developed into a sort of what would be described as a mature regulator with a sort of relationship that works with the sector that it's regulating. So the OFS says and keeps saying that it's changed and it's going to reset its relationship with the sector. But it doesn't really seem to work, or at least it hasn't worked yet. And there's sort of changes of messaging and some sort of nicer words, but then when it actually comes to the next regulatory requirement, the next policy, the next consultation, the next data gathering exercise, and indeed then you come to how it actually takes regulatory decisions on cases such as this one, Vice Chancellors don't see much change. I've said universities would like a regulator that worked with universities to solve the financial challenges universities face. Actually, if you speak to universities that have engaged with the OfS on finance, they're not very impressed by the work of the OfS on finance at all. Don't feel that the regulator has got a grip on that issue, and don't feel that it can offer them any solutions or insights into how to address their problems. So it's in a difficult place. You could say the natural conclusion of that is that we need a new regulator. We need a new relationship between universities and government, and indeed that you might have a regulator who, with that different identity, could achieve some of the things that government wanted to achieve in the post-school education sector. The obvious thing here would be to have a sort of proper post-school education regulator like you have in Wales that would bring together further education, higher education, and seek to achieve that collaboration, and indeed would just sort of reset the relationship completely. The problem is the government had the chance to do that. It's put out a higher education white paper. It's talked about collaboration. It's talked about specialisation in the sector. That would have been the moment to say, right, we're going to have a new regulator to deliver on this. It decided not to do that. And as I say, if anything, it's chosen to give more powers to the OfS. It just feels that politically there perhaps isn't the bandwidth in government or the appetite to do major regulatory reform at a time when the sector's in a pretty difficult place. But look, the government is in a pretty difficult place as well. So it may be that for now we are where we are with the OfS as a regulator. What it does have is 2 new chief executives coming in a month or so's time, who are sort of, I think, respecting the sector and clearly do offer a chance to change that narrative. It's got a relatively new chair, Edward Peck, who was the former Nottingham Trent Vice Chancellor. So again, someone from the sector himself as well. So I think if there's going to be a reset, it's likely going to have to come from within the OfS and how it handles that relationship with the sector, as opposed to a complete redrawing of the architecture of English higher education.
So, while the University of Sussex celebrates this week, the leadership team at the OfS will no doubt be carefully examining the details of this finding and reflecting on how it will shape its future operations. It will be interesting to hear more if or when discussions between Sacha Rosenhill and the Education Secretary about sector regulation take place, as this is a far from settled debate. Chris, thank you so much for joining me on News Talks this week.
It's a pleasure.
And that's it from us, folks. If you enjoyed the podcast, please do like, share and subscribe, and we will be back with you in a couple of weeks. Thank you. Bye-bye.
You're listening to a Times Higher Education podcast.